The Pretoria High Court will today hear former Public Protector Advocate Busisiwe Mkhwebane's urgent application to compel the Public Protector South Africa to pay her a 10 million rand gratuity she claims she's entitled to. However, the office of the PP argues that Mkhwebane is not eligible for the payment. For more on this, we're joined on the line by legal analyst Mpumelelo Zikalala. Very good morning to you, sir, and welcome.
Good morning to you, and also good morning to your listeners.
First, tell us, what do you understand to be the legal basis for the Office of the Public Protector's refusal to pay the gratuity to Mkhwebane? Is there precedent to this?
Not entirely. I think it's the first time in which our courts will deal with this matter, especially from the side of the Public Protector. But the office is saying that the condition of you getting the gratuity is that you're supposed to exit in a normal manner, meaning exit in a manner that has been prescribed in the Constitution by your term expiring and not by you being fired. So in this case, if you are fired, then it means you don't get the benefit which is associated with the normal exit, if I put it in that context. So that is what the Office of the Public Protector is saying in its defense of not paying the gratuity.
What is the significance of the claim that Mkhwebane left the office in financial dire straits, and how could this impact the case?
Well, I think what the office is trying to say, this is supposed to be, I liken it to a performance bonus. So if you haven't performed in a proper manner, why should we then give you a token of appreciation if you have left the office in dire straits and you have left it in a manner in which it does not even allow it to have the money to pay for that particular gratuity? So we need to go back and say, what did the contract of employment say? What did you promise each other? Let's look at what the law is actually saying in terms of those particular purposes and check who is interpreting the law in a proper manner between the two individuals.
Now, the current Public Protector says that Mkhwebane has no right to that gratuity, as she did not vacate the office but was rather removed from office for serious misconduct and incompetence. How does the Public Management or the Public Finance Management Act 1999 apply to this case, particularly in terms of safeguarding the public funds?
Now, you see, when it comes to that, actually, it then says, if you're at the helm, for example, you're an HOD or the Public Protector, you are the one individual that has been entrusted with the funds of the entity, and you are supposed to implement all the safeguards that are implemented or proposed or prescribed by that legislation. And if there's any mismanagement that has taken place, the blame then falls on you. So if you're going to have a situation where the office is not performing correctly due to flouting of any legislation which is applicable, then you are liable for whatever expenses that have been made. However, before you are liable, there's a procedure that needs to be followed. And I think in this case, that's maybe where the Public Protector's Office may be found wanting, that you need to follow. So you don't unilaterally do that particular act of deciding, this person is not supposed to get that gratuity, then I'm going to apply it. You go through a formal process, you give them an opportunity to respond. Once they've responded, they've gone through sort of, let's call it a mini trial. Only then you come back and say, your money has been withheld due to us trying to recover the money that you have caused the office to lose. So you don't unilaterally do it on your own without applying the proper procedure that needs to be applied. But again, what would need to be interpreted here is the stance of saying, was the gratuity going to be given if a person exits in a normal manner, meaning their term of office expires, they go in the term of office and they've left clean audits, for example. They've left the entity in good financial health, and every single thing that was given to them as a key KPI has been achieved. So all those things will have to be looked at and interpreted by the court.
Now, we're asking our listeners this question, but from a legal eagle perspective, does the former Public Protector, Advocate Busisiwe Mkhwebane, deserve that 10 million rand gratuity after she was removed and found guilty of misconduct and incompetence?
It would be very difficult to look at it because we need to first say what was the task given to the Public Protector at the start. So was it stated that you must make sure that all the cases are done and dusted within a certain amount of time, make sure that you have a clean audit, make sure that you live in an office that is healthy. If those indicators those three were not achieved when they were first agreed to, then you must come back and say, you did not achieve what we promised us to do. There's no gratuity which is going to be allocated to you. But if they are, then the only issue is that of misconduct, because that is a bit of subjective whether even the procedure which was followed correctly. then you must come back and say, we've agreed in writing that we're going to give you your money if you've achieved these things. We've achieved them. It's only fair that we do so. Unless there's a provision that says, even if you achieve those three things, if you are found guilty of misconduct, you're not going to qualify for them. Only then would I say they have elected in terms of refusing that amount.
I thank you so much for your time and your point of view. Legal analyst Mpumelelo Zikalala.
You can find SAFM Current Affairs on 104 to 107 nationwide. Our podcasts are available for download on all our digital platforms. SAFM, leading the conversation.